This is Dr. Saudamini Siegrist to talk to us about issues of child protection and transitional justice. Saudamini is an associate with Humanitarian and Development Partnerships International in child protection. She served as a senior advisor for child protection in emergencies at UNICEF from 2012 to 2017, and previously as child protection specialist at the UNICEF Emergencies Research Center and as chief of child protection for UNICEF in Palestine. She also worked in the Humanitarian Policy Unit of Emergency Operations at UNICEF on issues related to children and armed conflict, international criminal justice, and monitoring and reporting of grave violations against children. She was seconded to the Sierra Leone Truth and Reconciliation Commission in 2003 to 2004 as rapporteur and writer for Children's Truth and Reconciliation Commission report. She also served as lead writer for the publication Children and Truth Commissions, co-authored by UNICEF and the International Center for Transitional Justice. She co-edited the book Children and Transitional Justice, Truth-Telling, Accountability and Reconciliation, published by the Human Rights Program at Harvard Law School, and contributed to The Impact of War on Children, authored by Rasha Mashel. She holds a doctorate from New York University and a master's degree from Columbia University. So Saudamini, over to you.
Thank you. Thanks. Good afternoon. Many thanks to Dr. Sheila and to Jaslika and for today's invitation to join the webinar on children and human rights. As you noted, I'll be speaking more specifically about children and transitional justice. When UNICEF first started working on children and transitional justice, the question most often asked was, why children? What do children have to do with it? That's because transitional justice was seen as highly politicized with potential benefits, but also risks. The working definition, just to be clear, on transitional justice in the 2004 Secretary General's report is the full range of processes and mechanisms associated with a society's attempts to come to terms with large-scale human rights abuses and to ensure accountability, to serve justice and achieve reconciliation. So that includes both judicial and non-judicial processes, individual prosecutions, reparations, truth-seeking, and institutional reforms. There's a range of activities. But involving children in transitional justice didn't happen all at once. It evolved over time, and it's still evolving. So the answer, in short, to the question, why children, is that when transitional justice mechanisms address crimes committed against children in armed conflict or political violence, then children have an important role to play. That's because they are the victims and witnesses of the crimes and may also have been recruited and used in hostilities. In addition, as family members and citizens of their communities in their own right, children are partners in reconciliation and recovery. So in the early 2000s, truth commissions and international tribunals started looking at involving children in their processes based on the right to participation, as noted in Article 12 of the CRC, and also based on the best interest principle that is at the heart of the Convention on the Rights of the Child and maintains that all decisions should take the best interests of children into account. So how are the best interests of the child understood in the context of transitional justice? An interesting illustration of that point can be found in the decisions taken by the South African and the Sierra Leone Truth Commissions regarding children's participation in statement taking and in thematic hearings. In 1996, at the time the South African Truth Commission, there was a debate as to whether or not children, that means under age 18, should appear and testify during the special hearings on children and youth. There was no precedent for children's participation in such a process, and there were concerns that children could be re-traumatized as a result. Consultations took place with UNICEF and some 30 South African NGOs, and they concluded that the participation of children would expose them to too many risks and would not be in their best interests. And so children were excluded from participation in the statement taking and in the hearings. But 5 years later, in 2001, the Sierra Leone Truth Commission used the same argument, the best interests of the child, to arrive at a different conclusion. It was decided that because children were among those most affected by the civil war in Sierra Leone, their involvement in the Truth Commission was essential. It was determined to be in their best interests to participate. The question was not whether they should participate, but how to make their participation safe, how to make sure that it would be in their best interests. So participation and protection had to go hand in hand, had to be mutually reinforcing. It was necessary to put in place protocols and procedures that would protect children and provide psychosocial support throughout the process. A vulnerability assessment was developed, a safety checklist, a framework of cooperation between the Truth Commission and the child protection agencies. And it wasn't perfect, but children's views were taken into consideration in the accountability process, both in the Truth Commission and in the Special Court for Sierra Leone. And the decision of the Sierra Leone Truth Commission to include children resulted in over 300 statements from children and established precedent that informed the Liberia Truth Commission in 2006 to systematically include children in statement taking and in the regional hearings, with nearly 300 statements by children. More recently in Kenya in 2011, children were included in the Truth Commission with nearly 1,000 children giving statements, about 40 participating in the thematic hearings. So this evolution of thinking and decision-making with regard to children's best interests in transitional contexts means that the principle is not fixed or rigid, but should be adapted and informed by the local context, taking into consideration children's views and their experience as victims and witnesses. In 2003, I served as the rapporteur for the children's version of the Sierra Leone Truth and Reconciliation Commission report and worked together with the Children's Forum Network in Sierra Leone. That was a national group of children selected as representatives, also with the Voice of Children's Radio, the first ever Children's National Assembly. The kids we worked with were dynamic, engaged, articulate, and they were the driving force behind the report. That included girls, and although they faced greater challenges and struggled for equal voice. A very important point is that in statement after statement, the children expressed loud and clear their number one priority in the aftermath of the war. That was overwhelmingly education. They wanted education to access opportunities for the future. In 2010, when we did research on children and transitional justice, working with Harvard Law School and with a range of stakeholders, education was for the first time included in a transitional justice agenda. It had been missing. There was a gap. That's significant because child protection and education are community-based efforts, intergenerational, and they have a highly significant impact on long-term recovery. From 2012 to about 2016, as a component of UNICEF's peace-building education and advocacy program, case studies were conducted on education efforts that support and have supported transitional justice in the Middle East, in Asia, in Africa, Europe, Latin America, North America. And the case studies document both formal and informal education reform, including curriculum reform, teacher training, reparations, programs linked to education, recommendations by truth commissions on education reform, informal education projects addressing memory, memorial, legacies of the past. And it was determined that educational reform in child protection focused transitional justice efforts, engaging children in discussion and dialogue, are a key priority for transitional justice. And that the exercise itself, engaging children in discussion and dialogue in a safe environment, can build their skills in negotiation, critical thinking, and communication. So it's a capacity building exercise. The work that has taken place since that time, documented in Sierra Leone, South Africa, Liberia, Peru, Colombia, Canada, Guatemala, Kenya, Nepal recently, Sri Lanka, all point to that potential for positive impacts for children and for their families and communities. There's a new handbook on political violence and children coming out by Oxford Press in September that highlights in particular interventions and preventions dealing with children's involvement in these contexts. But it's not a quick fix, and there's no formula. Building peace and establishing human rights and a safe place for children to realize their potential in the aftermath of violent conflict is a long haul. In all cases, the journey must be owned by the community, by families and children themselves. So a few takeaways on lessons learned to keep in mind. As we said, children are key actors in accountability and reconciliation processes. However, this does not mean that the burden of justice and truth-seeking should be shifted onto the shoulders of children. It should not. But children should be given a place and a voice in those processes. Children's recovery from grave violations does not begin or end with transitional justice. Entire lifetimes may be spent in the effort to reconcile and to recover. We talk about genuine participation, the ladder of participation, the importance of child-led participation, and so on. But when it comes to transitional justice, the mechanisms are inherently political. So that should be recognized. What is the appropriate platform for children? This question came up in Nepal when a truth commission was proposed as part of the peace agreement at the end of the civil war in 2006. And to this day, it hasn't been convened. But the young people we met with in discussions were not in favor of a truth commission or any commission for that matter. They were disillusioned by too many broken promises. What happened instead was a national youth dialogue, which provided a platform for children and young people to reflect and engage. Also in 2010, UNICEF and the Human Rights Program at Harvard Law School published the key principles for children in transitional justice, which outline the protocols and protections needed so that children can participate safely. For example, the best interests of the child should guide children's participation from start to finish, and the safety and security of the child is paramount. Under no condition should be compromised. So the direct participation of children should be conducted only when there's physical protection and psychological well-being fully supported throughout, together with the child's family and community. All participation must be voluntary with informed consent of the child and the child's parent or guardian. So it's up to the child and the guardian to decide for themselves whether to give testimony. And a child may change her or his mind to decide to withdraw at any time. A decision not to participate is also participation. Children's participation, this is important, must be realistic and realizable and meaningful from their point of view. Because raising unrealistic expectations leads to frustration and it can be damaging. Special attention is needed for girls to address their specific needs and vulnerabilities, in particular girls who've been targeted for sexual violence. And children's statements or testimony in a truth commission or in a court should be in a child-sensitive environment. Children's names and identities, and all testimony should be confidential. There was the case of the first trial at the International Criminal Court, prosecuting the crime of child recruitment. The first witness called in that case was a child who testified in open court against the defendant, Thomas Lubanga. The protective measures employed did not include shielding the witness from the accused. And after testifying in the morning, the witness, a former child soldier, returned after the lunch break and recanted his testimony. The child was distressed, intimidated, and fearful. After that, witness protections were put in place by the ICC, and they developed a policy on children with protection protocols for the best interests of the child, also with the understanding that child witnesses should be called to testify only when there is an absence of other evidence. So I'm going to wrap up now with just 3 points, and then hopefully we'll get to address other points in the Q&A. First, the participation of children and young people in reconciliation and peace building is a proven, tried, and tested course. The kids have made the case themselves. The second point, that transitional justice cannot be imposed or determined by an outside or international agenda. So the international community has to step back and let those who experience the violence find their way to come to terms with those experiences and rebuild. That's the message of local, traditional, indigenous processes, the need to be determined by local contexts and led by local actors. Lastly, international support is needed and may be indispensable in some situations, but as the rapporteur and writer for the children in Sierra Leone who participated in the drafting of the children's version of the Truth and Reconciliation Commission report, I have to say that the children I worked with did not need anybody to tell them what to do. They needed opportunities to express themselves and to put their ideas into action. In fact, many opportunities were lost along the way, so we can't really afford to give up. We just have to keep trying and learning and letting these processes evolve in the best interests of children. That is not to say that you cannot accomplish transitional justice without children, but if you leave children out of the picture, the loss will be significant and it may have serious consequences in the long term. Thank you.
Thank you so much for that, Saudamini. I think there was a lot in it that we need to digest and understand. You've talked about lost opportunities, and we really cannot afford to lose any more opportunities because the consequences can be disastrous. I'd like to ask you one question now, and then later we can come back to more questions. And just at this point, just take maybe 2 minutes to answer the question. And you could expound on it later, but just give us the essence of the answer. So this is a question from Iqbal from Nairobi. And he asks, how do the children who have committed violations make peace or reconcile with the victims and the community? And do they face any kind of legal responsibility for the actions?
Okay, that's a very complex and important question. It's been a debate in the years of pursuing the participation of children in these processes. I should mention, first of all, the CRC does not set a minimum age for criminal responsibility. That's a national legal determination. But when it comes to international crimes, and that's what we're dealing with in this context, according to the Paris Principles, which is a very important norm and standard in this regard, children under 18 accused of crimes under international law allegedly committed when associated with armed forces or armed groups should be considered primarily as victims. So that's the idea that in reconciliation, I mean, there are options like restorative justice. There's no one set way. It's also important to note that the International Criminal Court does not have jurisdiction below the age of 18. So they don't prosecute for children. Children are not to be understood as having primary responsibility in the perpetration of these crimes. Interesting also, the special court in Sierra Leone was mandated to prosecute to the age of 15, but the policy of the court taken by the chief prosecutor, David Crane, was not to pursue criminal responsibility below the age of 18 because it was understood that children were not among those primarily responsible for the crimes that were committed. So the involvement of children is, it will be dependent on a specific situation, but these are the, let's say, trends in addressing the situation for children, that they should be primarily considered as victims. That's not to say they don't have agency. They do, and in accordance with their evolving capacities. That's Article 5 of the Convention. And by the way, I should mention this new issue where over 40 countries have actually passed new legislation or laws in for foreign terrorist fighters. And that, frankly, jeopardizes child protection by Children's Association forcibly recruited or in other ways influenced. So again, just to sum up, it depends on the situation, and there can't be one answer to that question. It's a very complex question. Primarily, we are looking for reconciliation and for the recognition of children as primarily victims of these this conflict, violence, and crimes. Yeah.
Thank you for that, Saudamini. That was very interesting, and I'm sure we will carry on with this discussion. It's a very complex issue, as you said, especially now when we see children are forcibly recruited into as terrorists, as child soldiers. So should they really be prosecuted for something that they may not have fully understood and they may have been forced into doing? So thank you very much. We'll come back to you later. You want to add something? No, that's okay.
Well, just that the kids I work with, I mean, a number of them are really leading advocates on these issues now today, 10 years later.
Mm-hmm.
What they can bring to the discussion and the understanding. Yeah.
Yeah.